doing extremely amazing, people. So people, we had begin with our next chapter of insolvency and bankruptcy code, right? So in the next chapter, we had begin with the chapter called as liquidation of a corporate person. Okay, people, I've told you, whenever a company is going through a financial distress, it has got two options. Number one is either to revive itself, that is CIRP. Number two is, if reviving is not possible, we need to liquidate the company. So we are studying the liquidation of a corporate debtor chapter. Yes or no, people? Perfect. So people, under this chapter, we have completed how many topics? Number one, we understood to which all entities, to which all persons insolvency bankruptcy code 2016 is applicable. Okay. Then people, we understood the definition of related party. The definition of related party is very different from the Companies Act 2013. Yes or no, people? Okay. Number three is, people, under what exceptional situations liquidation order can be given by NCL2, we understood. NCL2, NCLT also we understood, people. Okay. The number four, people, we understood after liquidation order what can be the actions that will be taken by the liquidator. Okay. Then people, we understood what are the powers, what are duties of the liquidator. Perfect. Then people, we understood once NCLT has given an instruction to the company that you have to get liquidated, now what? Now you have to sell the assets. Now to sell the assets, what all assets will be included and what all assets will be excluded. Yes or no, people? Then people, we understood avoidance of preferential transaction. If a company gives preference to a certain creditor before insolvency, that creditor will have to repay or restore the benefits back to the corporate person, so that all the creditors will be treated in a fair manner. Yes or no, people? So till here we covered our liquidation of a corporate person chapter. Okay. Now people, today what are we going to do? Today we are going to cover four topics. Number one is, what is the meaning of undervalued transaction? What is the meaning of undervalued transaction? We will understand. Next is, people, number two is transactions that has been carried to defraud the creditors. We'll understand in detail. And 10th and 11th is beautiful topics. 10th is distribution of assets. So once liquidation estate has been identified, now that assets are sold off, now we have got money. Now with this money, to which type of creditors, to which category of stakeholders will be given priority in case of repayment? We'll understand. Beautiful topic, people. And the last is secured creditor. What are the options, what are the choices that are available to the secured creditors in enforcing their security? We will understand. Either they can sell their assets, or what they can do, they can choose to go with other creditors. They can give a strict order to liquidator that we don't want to sell the assets. We want you to sell the assets, and please pay us when you are paying to all the other stakeholders. This is called as relinquishing security interest. We understand how he'll be treated. Every single thing we are going to understand today, people, right? Perfect. So four topics are remaining, and then people, what we are going to do is we are going to revise the entire chapter in just half an hour. After that, we will be solving past year's question papers. After that, we will be solving the expected questions. Okay, perfect. Chalo people, chalo. Let's get started. Now we are going to study undervalued transaction. Okay. Yes. So people, what is the meaning of undervalued transaction? We know the meaning of preferential transaction. Yes or no? If one creditor is given priority over others, it is called as preferential transaction. But over here, people, over here, you are not giving preference to anyone. You are underselling your assets for a very less value, so that creditors cannot get maximum value from your assets. That is called as undervalued transaction. We'll understand. If you are selling machinery worth 10 crores 10 crores is the value of the machinery and you are selling it for what price? You are selling it for 1 crore 6 months before insolvency. It is called as undervalued transaction. First of all, you cannot sell your asset at such a dirt cheap price because it's against the interest of creditors. Yes or no, people? So IBC law is only made to protect the interest of the creditors plus maximize the asset recovery value. Yes or no, people? Perfect. Chalo. Now let's get started. What is the meaning of undervalued transaction? What all transactions will be covered under undervalued transaction? Let's understand. People, an undervalued transaction, a transaction is undervalued if the transaction is for a very, very less value that we know. Selling assets worth 10 crores to just 10 lakhs or 1 crore. Transactions where value received is significantly lower than market value. If you do this, it will be called as undervalued transaction. Again, the person to whom the assets was sold, they have to restore the benefits. Okay. Now people, there is one more category of undervalued transaction. That is called as gift transaction. A gift made by a corporate person. So he is not underselling his assets. He is giving the assets for free. People, do you think it makes sense for the creditors? Never. So a transaction is undervalued if two things happen. Number one is if you are selling it for a very, very less value. People, 1 second. I will just adjust the position. Okay. Yes. So if you are selling the assets for a very, very less value, number one, or you are giving the assets for free of cost, it will be called as undervalued transaction. Now, what is the relevant period? It is same as preferential transaction. If you are selling it to related parties, 2 years before insolvency commencement date will be calculated. If it is not a related party, 1 year before insolvency commencement date will be calculated. So transaction within 1 year before insolvency, and if it is related party, it is 2 years. Very simple, we already know this. Now who can make an application? Liquidator can make an application that this corporate person, Kingfisher Airlines, has sold airlines at such a dirt cheap price to their sister concern, to their related parties. Is it allowed? No. Or resolution professional or creditor or shareholder or partner can apply to the NCLT to declare those transactions as invalid, to declare those transactions as void. You know, 1 second, this monitor just keeps on flickering. Okay. All right. Now people, what are the possible orders that can be given by NCLT? Will understand. NCLT will first ask the person to whom the property is sold to return the property. Very easy. Number two, before we come to number two, let's come to number three. Repay all the benefits that they received. Yes or no, people? Property transferred in undervalued transaction to be returned. This is very easy. Next is parties involved to pay sums for the benefits received. Very easy. Now let's come to second point. Release or reduce security interest. Sir, but security interest was not created at all. We were talking about selling the asset at a far less price. Then how is security interest created? Now people, listen to me very, very carefully. If X and Y are creditors, and you are the corporate debtor, you are the corporator, you have given your factory as a security, if let's say 1 CR is repayable to X and 2 CR is repayable to Y, obviously you should give priority to 2 crores, right people? But over here, what are you doing? You are keeping the factory as a security. And what is the value of the factory? 10 crores. You're keeping such a high value factory as a security to X. First of all, it is not allowed. So, If such type of transactions are entered, NCLT will ask to release or reduce the security. They will ask that you have to keep some other assets equivalent to value as security. You cannot keep such a high value factory for such a small amount of loan as security. Very, very simple. Yes or no, people? So this is called as undervalue transaction. Now let's people understand using mind maps. So a transaction is undervalued if two things happen. If you are giving the assets for free of cost, or if you are selling the assets at a very, very less price. Gift made by corporate person, transaction for less value, transaction where value is less than the market value. Very simple. Okay. Now, what is the relevant period? If it is related party, it is 2 years. If it is non-related party, it is 1 year. We know this. Now, who can give an application? Liquidator can give, a resolution professional can give, creditor can give, member can give, partner can give. They can apply to NCLT to declare the transaction as void. To declare the transaction as void. People, I did a small spelling mistake over here. It is void, okay? Not a void. Perfect. Now that the following categories of people have given an application to make sure the transaction is declared as void. Now, what all orders can be given by NCLT? Number one is they will ask to return back the property. Last is they will ask to repay the benefits, and number two is they will ask to release or reduce the security interest. Very, very simple, people. We are understanding every single law using logic, people. Yes or no? Perfect. So we are done with the undervalued transaction. Now let's come to transactions that has been entered to defraud the creditors. Okay, to defraud the creditors. First is preferential transaction. You are giving priority to one creditor over others. Number one. Number two is you are selling your assets at a very, very less value because you don't know that what is the value of assets. So you are doing things lawfully, but you are underselling your assets. Okay. Now number three is, people, there is your intention to defraud the creditors. There is an intention to defraud the creditors from the side of the corporator. Now let's understand, people. If you have transferred assets of your company, if you have transferred your company's assets to a friend for a very, very less price, that is not important. But the important point is you are selling the assets to hide that assets from the creditors is called as assets sold to defraud the creditors. You are selling the asset at a far less price. Yes, that is agreed. But what is the intention? Your intention is creditors should not get hold of these assets. That is your intention. Your intention is, chalo, after insolvency is done, what I will do is I will take back the assets from my friend. People, then it is a completely void transaction. It is completely unlawful transaction. So let's understand, people. Now, a fraudulent transaction is one where two things happen. Number one is you are hiding assets, prevents creditors from accessing the assets. Number one. Number two is you are in some way you are harming the interest of the creditors from realizing maximum value on the assets. Affects creditors' ability to recover debts. So if you are harming creditors in any manner, then it's called as transactions defrauding the creditors. Very, very simple. Now, what could be the possible orders that can be given by NCLT? Two types of orders. Restore the position of the creditor if this transaction would never have happened. Reverse fraudulent transaction to return assets to the debtor's estate. Number one, estate means liquidation estate. Number two is protect the victims. Reversal of transfers or compensation for harmed creditors. So whoever were the victims in these type of transactions, they should be again restored. They should be protected. This is called as, people, reversal of transfers or a compensation for harmed creditors. Whatever harm has been caused to the creditors, you have to now give them compensation. Yes or no, people? That's it. Let's come back to the mind map. Transactions defrauding creditors. A fraud transaction is one that does two things. Either you are hiding the assets to prevent the creditors from accessing the assets, number one. Number two is you are harming the interest of the creditors, affecting their liability to recover debts. This is not correct, people. Yes or no? Okay. Now, what the NCLT can give? They can ask to restore the position. Yes or no? Number two is they will ask to protect the victims, reversal of transfers or compensation for harmed creditors, or to return the assets to the debtors. To return the assets to the debtors' estate. People, this is estate. Very, very simple, people. People, just one sec. Perfect. Okay. So, people, next topic that we are going to study is very, very interesting. Okay. Now that we understood what all assets will be included in the liquidation estate, what all assets will be excluded from the liquidation estate. Now, people, liquidation estate has been now sold off. Okay. All the money has been now recovered. Now what? Now what are you going to do with this recovered money? To whom are you giving? To whom are you going to give priority? To unsecured creditors first, to secured creditor first, or to that creditor who has given away his right to enforce his security interest, or you will give your sale proceeds to the workmen, or you will give sale proceeds to the employees, or what about insolvency resolution professional? What about the government dues, taxes payable? What about the preferential holders? What about the equity holders? If everyone keep asking us, to whom are we going to give priority? This is every single thing has been written down in Insolvency Bankruptcy Code 2016. Okay, very, very simple. So let's get started. Before that, I will drink some water. Chalo. Let's get started. Okay. So, people, distribution of assets during liquidation. I've given you also example, people. So, first, what we're going to do is, first we'll understand the priority. Yes or no? First we'll understand the priority, then we'll come to examples. So, there are 8 categories of stakeholders. How many categories, people? 8 categories of stakeholders. So, I hope you are able to see this, people. Okay. Now, first we'll revise from here, but we'll understand from this table because example is also mentioned over here. Okay. So, first priority will be given to whom, people? To that person without whom this liquidation estate cannot be sold. Any major decision cannot be taken without this person. This person is very, very important. So, who is this person, people? Insolvency resolution professional. You are going to pay money to first is insolvency resolution professional or the liquidator who has liquidated the company. Yes or no? Without paying to him, can you give it to anyone else? Imagine if these people have been paid in the last. Do you think these people will ever then try to do this job? No. So first priority should be given to insolvency resolution professional or liquidator. Example is fees of RP liquidator, all the legal cost, all the valuers fees. People, do you remember? I've told you liquidator can appoint professionals. Professionals can be valuers, auditors, lawyers, anyone. So whatever cost has been incurred by the liquidator, all the cost has to be first paid off. So all costs incurred in CRP and liquidation expenses are paid in full first before anyone else. So logic is simple. Number one and the most important person in the liquidation proceeds is insolvency resolution professional or the liquidator. Okay. Now next category of people are those who are very vulnerable, who are very weak. They should be given money, otherwise they will be very much damaged socially. Yes or no, people? Now who are these people? There are two categories of people. Number one is workmen, right, people? Laborers, the one who receives wages, laborers and all, they will be given priority. Plus one more category of creditors will be given priority, those who have relinquished their security, those who have chosen the difficult option. For example, if Lenskart has taken a loan from a bank, okay, Lenskart has given a security as bottle to take a loan. Now Lenskart, the moment Lenskart knows that, the moment that bank knows that Lenskart is into insolvency, bank can very easily sell this bottle and recover their money. But bank did not choose this. Bank told liquidator that liquidator, you take this bottle with you and you sell the bottle along with other assets. After that, whatever proceeds that we are entitled to receive, you give it to us. So the creditor is trying to become a bigger person. He is trying to become a bigger person. So obviously, people, the one who is bigger person and the one who are the most vulnerable stakeholder should be given priority. Yes or no? Perfect. So workmen dues and debts owed to secured creditors who have relinquished their security interest. Example, let's understand, people. Workmen's unpaid wages plus provident fund dues plus secured creditor who gave up security and opted to claim in liquidation pool. He has chosen a bigger choice. He has got a very big heart. He told to liquidator that, buddy, I cannot sell this bottle. I don't have time. So what you do is you sell this bottle and you sell all the assets that you have in liquidation state, and then please keep us as a preference. Please pay us along with all the stakeholders. Okay. Number two is very simple. So number one is insolvency resolution process cost or the liquidator process cost. Number two is workman dues. Now this is very important. For 24 months preceding the liquidation commencement date. So whatever is the company is supposed to payable, whatever Kingfisher Airlines is supposed to pay to the workmen who clean the toilets, who do all the small work, so they should be given priority in the last 24 months period before insolvency commencement date. So last 24 months period, money should be given priority. Very easy. Now third is very important. Over here, wages and unpaid dues to not workmen but employees for 12 months preceding the liquidation commencement date. So people, obviously after workmen will come employees. So pilots, air hostess, everyone will come over here. So what is the period, people? 12 months before insolvency commencement period, whatever money is supposed to be payable, they should be given priority after workmen's compensation and secured creditors who have relinquished the security interest. Yes or no, people? Perfect. Example is covers clerical, administrative, managerial employees not classified as workmen. Other than workmen will come under employees. Okay. Now next is, people, financial debts owed to secured creditors. Financial debt owed to unsecured creditors. Sorry. Unsecured creditors. Secured creditors who have given up the right to enforce the security interest, they are done. They have a bigger heart. They have been compensated. Now it is the chance of the unsecured creditors. Who are unsecured creditors? The ones who have not been given any security while loan has been obtained from them. If you take a loan from a bank and then bank has not asked you any security, that means that bank is an unsecured creditor. So it includes banks, NBFCs, the individuals who lent money without security. Very easy. Okay. Now after that people comes government dues. For the past 2 years, preceding the liquidation commencement date, and debts owed to people. There are two types of again stakeholders involved. Okay, number one is government dues payable for the last 2 years. Next is people, the secured creditor who have not relinquished their security interest. For example, I told you, remember people, if Lenskart has taken a loan from a bank and bank has been given security as the bottle. So bank has got two choices, either to enforce the security interest or either to be given priority along with other creditors. Yes or no? So the bank that has given up their security interest, they have been given priority. Yes. Now what about the bank which has chosen the easier option, which has chosen the first option, that I am going to sell these assets and I am going to recover my money. Now that bank has recovered money by selling this bottle, now why are they here for the money? The reason is people, if you have taken a loan from a bank for 100 crores and security is only 80 crores and bank has sold the security for the remaining 20 CR, bank is waiting for getting repaid. So debts owed to secured creditors for any unpaid amount after enforcing security interest. Also, if a secured creditor sells mortgage asset but still has some debt left unpaid, that balance comes over here. Very easy people. Every single thing along with logic we are able to understand. Now next is any other debts or dues like trade creditors, operational creditors beyond time limits. So all these other dues will come over here. And then people comes the shareholders. First you will give it to preference shareholders because they are preference shareholders, and next is you will give payment to equity shareholders because these are the one who were involved in causing financial distress to the company. So preference shareholders paid only if surplus remains after clearing all the high priority dues. That means what? After you pay to all the 6 categories of stakeholders, then only priority will be given to preference. After giving preference only, priority will be given to equity shareholders. Very, very simple. People, now let's come over here. So number one is insolvency resolution process cost and liquidation cost you will pay. After that people, one is very, very vulnerable and one is a person who has got a bigger heart. The one who has got a bigger heart is called as secured creditor, who has relinquished, who has given away the right to enforce his security. Number two. Number one is the one who are the most vulnerable part of the creditors, who are the most vulnerable category of the stakeholders. Who are the people? Workmen. Now workmen you will pay for the duration of which? What is the time duration? 24 months unpaid dues to workmen will be given priority. Okay. Now next is people, next is wages and unpaid dues to the employees other than workmen. Next is employees. Okay, employees duration is 12 months. For workmen it is 24 months. For employees it is 12 months. Okay. Now next is people, next priority is unsecured creditor. Let's come over here. Unsecured creditor. So after employees, it is unsecured creditor. Now after unsecured creditors, there are again two category of stakeholders who are given same priority. Number one is government dues 2 years, and then secured creditors who have not relinquished their security interest, who have enforced their security interest. Yes or no, people? And then any other remaining dues, after that preference shareholders, after that equity shareholders. So this is called as, people, waterfall arrangement. You give priority to stakeholders in this manner. Yes or no, people? So again, let's revise. Number one is you're going to cover the important part: insolvency, IRP cost, and liquidation cost. Yes or no? Number two of the most affected category of people: one who has got a bigger heart, one who are the most vulnerable. Most vulnerable workmen, 24 months. Who has got a bigger heart? Secured creditors who have relinquished their security interest. Okay. Number two. Number three is, people, employees last 12 months. Yes or no? Next is, people, unsecured creditor will come. Okay. After that, government dues for the last 2 years plus secured creditors who have not relinquished security interest, who have enforced their security interest. After that, any remaining debts or dues. After that, preference shareholders. After that, people, equity shareholders. So this is called as, people, waterfall arrangement. In exam, question can be easily asked. This is very, very important, people. 100%. This is extremely important. For 7 marks, easily question can be asked. And people, I have told you, I have explained you using logic. What more do you want, people? Simply learn this. I am sure by now you are thorough with this topic. Yes or no, people? Perfect. So now let's come to our last topic of liquidation. So, very simple, extremely easy topic. So I told you, people, creditors have got two options: either to enforce the security interest, either to sell the security and recover the money. Number one option is that. Second option is they can choose not to. First option is they can relinquish their security interest. They can give away the right to enforce the security. Number one. Number two is they can choose not to relinquish the security interest. Yes or no? For example, I will again tell you, people. Lenskart has taken a loan from HDFC Bank. The loan amount is 100 CR. Lenskart has been admitted for CIRP or liquidation. So HDFC Bank has got two options, and security, okay, security is, let's say, security can be given as they have an AI technology. Lenskart has given an AI technology, or let's say, very simple, people, let's keep building as security, or let's keep building as security. The value of the building is, people, the value of the building is, let's say, 100 crore rupees. Yes or no? 100 crore rupees, or we will take as 150 crore rupees. Okay, the value of the building is 150 CR. So HDFC Bank has got two options: either to sell the building or to not to sell, give power to the liquidator. That is called as relinquishing security interest. Okay, till here, let's understand this. The creditor gives up their claim to the secured asset receiving proceeds from its sale in liquidation. Okay. Next is realizing security interest. The creditor enforces their security interest, directly recovering the debt by selling the asset. Okay, very, very easy. Now next is called as enforcement of security. Now people, there is a very, very thin line of difference between not relinquishing security interest and enforcing the security interest. Enforcing means what, people? You take position and you have the right to sell. You take position and you have the right to sell. This is called as enforcement of security. The secured creditor can enforce, settle or deal with the secured asset according to the applicable laws to recover their debt. First of all, let's say HDFC Bank does not have possession of the land. Till now, land was with Lenskart. Okay. The moment HDFC chooses to sell that building, first they have to take possession, then they can do anything with the assets to make sure they can get maximum. They can sell the asset, they can put it on rent, they can do whatever they want. This is one thing. Next is, if Lenskart has kept its stock, Lenskart has kept its stock with the HDFC Bank as security, HDFC Bank can simply sell those stock. That is called as not realizing, not relinquishing security interest and realizing the assets by selling it off. Yes or no, people? Very thin line. Over here, there is possession plus right to sell, but over here, there is no possession. Possession is already with the HDFC Bank. Okay. Next is, if Lenskart tries to cause hindrance, tries to resist HDFC Bank from claiming the position, from selling their building, HDFC Bank can go to NCLT to enforce their rights. Very simple. And last is supposing HDFC Bank has given a loan of 100 CR, but when they sold of the security, they sold it for 150 CR. So whatever extra money has been received by the HDFC, is it their money, people? No. They have to return it back to the liquidator. They have to return it back to the liquidator. So 4 points we understood. Number 1 is options for the secured creditors. Number 1 is relinquish or not to relinquish. Number 2 is enforcing. Number 3 is if resistance has been caused, they can go to NCLT. And number 4 is whatever surplus have been realized, they have to give it back to the liquidator. That's it, people. We are done. Chalo. Now let's quickly revise every single thing we have studied till now. Now applicability of IBC. Applicability of IBC. Number 1 is companies incorporated under Companies Act 1956 or 2013, or company incorporated under Special Act of Parliament. Okay. LLPs also are included. Number 3 is any other body corporates notified by the government are also included. And next, people, partnership and individuals. And next is personal guarantors to the corporator. To them, IBC 2016 will be applicable. Now, which type of entities are excluded from the IBC? All the financial sector companies are excluded from the IBC. Which are those, people? Number 1 is bank. Number 2 is NBFCs. Number 3 is insurance company. Number 4 is asset reconstruction company. Number 5 is mutual fund. And number 6 is, people, pension funds. Very simple. Okay. Now next, what is the meaning of related party? Number 1, partner, director or the relatives. Next is KMP or the relatives. Next is firm. Now we are going to talk about firm, private, public. Now let's talk about firm. Firm in which director, manager or the relatives are a partner in that firm. Next is private company in which director, manager or the relatives are member in that private company, plus they are holding more than 2% shares in that private company, and same thing will be applicable to public company. But over here, director or manager is a director plus he holds more than 2% of paid share capital along with his relatives. Yes or no, people? Perfect. Now, let's talk about the entities. Any body corporate whose board, MD or manager acts as per the instructions or directions given by the director or manager of the corporate debtor will also be considered as a related party. Next is, people, any person on whose advice or directions the corporator is accustomed to act. corporators, directors, managers are accustomed to act. Okay. Next is any body corporate, holding, subsidiary, associate, or all the subsidiaries of the holding company. Step subsidiaries. Everyone will be called as a related party. And last people, any person or an entity that holds more than 20% voting rights in the corporate debtor, that person will also be considered as a related party. Very easy. And last is people, all the people or the entities involved in the policy making decisions of the corporator, number one. Number two is having more than two directors in common. And number three is people sharing or exchanging KMP is called as related party. Very, very easy. Okay. Now next people, under what situations liquidation can be ordered by NCLT? 4 situations. If you have not received any resolution plan on time, number one. Next is people, whatever plan has been submitted, that plan has been rejected by the NCLT for non-compliance. Number three is people, COC, Committee of Creditors themselves are saying that we want this company to be liquidated. And next is, even if plan has been approved in time, even if plan has been implemented, but you have violated the conditions stipulated in the plan, you cannot proceed forward with the resolution plan. So in that case, liquidation order can be given by NCLT. Very easy. Okay. Now next. Now what after liquidation order? Immediately public announcement must be made by the liquidator within 5 days of appointment. For what purpose? To invite claims from the stakeholders. Number two is you have to notify the registrar and all the regulatory entities, ROC, IBBI and others. Okay. Next is, now that NCLT has started insolvency, no new proceedings can be initiated by the corporator or can be filed against the corporate debtor without prior approval of NCLT. Next people, last is liquidator can sue, liquidator can defend the corporator provided they have got NCLT's approval. Very, very easy. Okay. Now next, what are the powers and duties of the liquidator? Okay. Number one is people, very easy. If the liquidator finds out there is some fraud going on, he can investigate. Number two is he has to verify the claims of the creditors. Number three is he has to take custody and control over the assets. Yes or no? Number four is once he has taken custody or control, he has to now evaluate the value of the property. Yes or no? Then he has to protect and preserve that property. Okay. Next is you have to continue the business if it is beneficial, like hotel business. Remember people. Next is you can sell the assets plus you can also sell the actionable claim. What is the meaning of actionable claim? Actionable claim is a legal right to recover the money by the court order. You can sell this right also. Okay. Then you can execute all the documents and legal instruments. Okay. Now next is you can seek direction, you can seek guidance from the NCLT. Perfect. You can initiate or defend the legal proceedings. Next is you have to invite and settle the claims. Over there we understood verify, but over here invite and settle. Next people, that liquidator has the power to appoint professionals and experts. Next is managing the estate of the corporator, that is right, but you can also manage the estate of the contributory who is supposed to pay to the corporator. Very simple. Next is that liquidator can deal in negotiable instruments. And last is perform duties assigned by the board. Board means Insolvency Bankruptcy Board of India. Very easy. Okay. Now you can also take consultation from Committee of Creditors. You can take consultation of the stakeholders, but it is not binding on the liquidator. Perfect. Now, what all assets are included in the liquidation assets estate? Number one is assets owned by the corporator which are in possession. Assets which are not in possession of the corporator, that will also be included. Next is all the tangible assets, movable, immovable, will be included. Next is all the intangible assets, immovable property, security and contracts. Every single thing can also be included. Next is assets with relinquished security interest. Remember, relinquished security interest, creditors has chosen to become a bigger person. Yes or no? Next is assets recovered via avoidance transaction. Those transactions which you should avoid. Next is disputed assets will also be taken into liquidation estate. And last is other assets vested on the insolvency date. And then people, liquidation proceeds. Whatever assets you have sold, the money that you have received is called as liquidation proceeds. That's it, people. Very easy. Now next. Okay. Now what all assets will not be included in the liquidation estate? What all assets cannot be sold by the liquidator? Number one is those which are third party assets held in trust, held in bailment, employee provident funds. Can you sell that? No, that belongs to employees. Government, all the government notified assets or funds, usage only contract, which means what? Company has taken this bottle on a rent. Does this mean company owns this bottle? No. So this bottle doesn't belong to the company. Yes or no? Next people, collateral with the financial service providers. Company has given or kept assets with the financial service providers for clearing their dues to ensure that company has got margin. In case assets value or shares value drop significantly, that company, financial sector companies can sell that asset. It is only for margin purpose. You cannot include that in liquidation estate. Okay. Next is subsidiary asset, whether be it Indian company, be it foreign company, you cannot sell the assets of the subsidiaries. And last people, obviously, personal assets cannot be included in the liquidation estate, whether it is of shareholders or whether it is partners. Why people tell me? Because company and shareholders, limited liability. Company is different, shareholders are different. And last is people, board specified exclusion. Which board? Is it Board of Directors? No, it is Insolvency Bankruptcy Board of India. If it thinks that certain assets shall not be included, they can be excluded. Oh, that's it, people. Now let's come to preferential transaction. Okay, people, just one sec. Oh my God. Yes. So where were we? Yes, avoidance of preferential transaction. What is the meaning of this, people? Transfer of property or transfer of interest by the corporate debtor that benefits a creditor, surety or guarantor and puts them in a better position than others are called, in case of liquidation, is called as preferential transaction. Sir, what is the difference between surety and a guarantor, people? People, if a person says that if A doesn't pay you money, I will pay you money. If A doesn't pay you money, I will pay you money. That means what? The creditor first will go to A. If A doesn't pay, then he will come to me. Yes or no? That is called as guarantor. That is called as guarantor. But what is the meaning of surety? It is one and the same. No, people. Surety means that person who can directly be arrived, who can directly be approached. That means what? Creditor can directly approach the debtor, or he can approach me. That is called as surety. I am the surety. Creditor can directly approach the debtor, or he can choose directly to approach me also. But in case of guarantee, is it the same, people? Guarantor is that person. Once the creditor goes to this person, if he denies the claim, then he will come to me. That is called as guarantor. Surety can directly come to me. That's the only thin line of difference. Okay. Chalo. So such transactions or transfers are voidable if three things happen. Number one, it is made during the relevant period. We understood, people? Number two is it is made voluntarily, not in ordinary course of business. It is not in ordinary course of business. Number three is even court ordered transfers can qualify as preferential transit that can be reversed back. Okay. Now next. What are the orders given by adjudicating authority? Number one is the transfer should be vested back to the corporator. Very easy, logical. Number two is if assets are not available, if assets are sold off, whatever proceeds you have given, it should be transferred back to the corporator. Next is direct repayment. Even if you don't choose to transfer the assets back, NCLT will ask you to revest back the money, equivalent money, whatever benefits you have received, you have to again pay back. Okay. Next is provision of security. Provision of security. If you have given priority to a certain category of creditor, you have given him security, then NCLT will ask you to again release back the security and then ask the corporator to enforce a new security. That should be right. Yes or no, people? And next is imposition of debt on the guarantor. The moment creditor's liability is reduced, guarantor's liability is also reduced, people. Yes or no? The moment debtor's liability is reduced, the guarantor's liability is also reduced. So NCLT will ask the guarantor to impose another debt. Yes or no, people? And the last is proof of debt. NCLT can ask the creditors that you have to now again prove your debt obligations. Very easy, people. Okay. Now next is undervalued transaction. A transaction is undervalued if two things happen. Transaction is for very less value or it is by gift. Relevant period 2 years if it's RPT. If it is not RPT, it is 1 year. Next is who can give an application? Liquidator, RP, creditor, manager or partner can apply to NCLT to declare the transaction as void. And the last is now NCLT will give what all types of orders? 3 types of orders. Number one is asked to return back the property. Number one. Number two, release or reduce the security interest. And number three is people, repayment of benefits. Very, very easy. Now next, transactions defrauding creditors. Okay. Now what is the meaning of this? A fraudulent transaction is one that hides assets or harms the interest of the creditors. That is called as, people, fraudulent transaction. Next is, people, what can the NCLT do? NCLT can ask the person to restore the position plus protect the victims by compensating them. Very easy. Chalo. Now let's come to distribution of assets. Number one, priority should be given to whom? Insolvency resolution process cost plus liquidation cost. So number two, priority should be given to workman dues past 24 months plus those secured creditors who have relinquished, who have given away their right to enforce their security interest. Number two is done. Number three is then you will give a payment to wages and unpaid dues to employees of the last 12 months who are not workmen. Next is financial debts owed to unsecured creditors. And number 5 is people, government dues 2 years. It is 2 years. 2 years prior to liquidation commencement date plus debts that is owed to secured creditor who have enforced their secured interest till they have got unpaid amount. Very easy. And last people, any remaining dues or debts after that, preference shareholders and then equity shareholders. Now people, let's come to over here, secured creditor. They have got two options, either to relinquish secured interest or to realize their secured interest. If they have received any surplus, they have to give back the proceeds to the liquidator. If they face any resistance, they can approach to NCLT to enforce their rights, and they can enforce, settle or deal in the secured asset. Basically, enforcing means they can take position plus they can do whatever they want with their assets to recover maximum value from the corporator's assets. So people, we are done with the chapter of liquidation of corporate person. I hope people, you enjoyed this lecture a lot. Okay, every single law that we understood, it was purely based on logic. We understood using example people, and then again we revised using mind maps 2 times. Yes or no people? Perfect. Now. Sir, now what are we going to do? Okay, now. Let's come to past year's question paper. People, I'm sure you're not going to like this because last year most of the questions have been asked from chapter of CIRP. But people, that doesn't mean that questions cannot come from liquidation chapter. No. Okay. It's a very, very high possibility that question can come from liquidation chapter. People, you tell me, I've drawn you mind maps, I've given you example, I've told you logic. What else do you need, people? Tell me. It's going to be super easy cakewalk for all of you guys. We have learned, we have understood using example, mind map, logic. Then we again understood using mind map. What else do you need? Okay, simply just quickly read it. Within 15-20 minutes, you'll be done with the liquidation chapter. Okay, yes or no? Perfect. Okay. Now let's come to past year's question paper. So people, in the year of December 2023, no question was asked from insolvency bankruptcy code. Yes people, no question has been asked from insolvency bankruptcy code. Let's come over here. This is from which year? June 2024. Who are the persons not entitled to initiate insolvency resolution process under IBC? Again, this is from the chapter of CIRP. Yes or no? Okay. So one question can be asked for 7 marks. Now people, let's over here. Under section 28 of IBC, RP will have to take prior approval for some cases, otherwise it will be invalid. What are those cases and what percentage of voting rights is required in favor of that decision? Again people, this is from the chapter of CIRP. Okay. So people, there is a very, very high possibility that question can be asked from liquidation of a corporate person, this time for 7 marks. Again people, let's look at it over here. Discuss about the management of affairs of corporators by interim resolution professional under IBC. Okay, how the affairs will be managed. Every single thing people, again, this is on chapter of CIRP. Yes or no people? So now you know that how important the chapter of CIRP is, plus you also know how important liquidation of corporate person might be for your future exams. Yes or no people? Okay. So now what? Now what we're going to do is, we're going to solve expected question that is going to be asked for the exam. So how many questions are there, people? 1, 2, 3, 4, 5, 6, 7. Okay. Same thing, people. Let's quickly go through it so that you will start to be familiar with the expected question and then you will start to learn. Okay. It should not be a new thing for you. Cool? Chalo. A manufacturing company XYZ Limited has defaulted on its loan repayment to a consortium of bankers. Consortium means a group of banks. Okay. The company is facing financial distress and its creditors are considering initiating insolvency proceedings. Discuss the applicability of Insolvency Bankruptcy Code 2016 in the case of XYZ and explain which entities are covered under IBC, providing relevant examples. So you have to simply give examples and points of to which category of persons, entities IBC 2016 is applicable, along with examples which I have already given you, people. Yes or no, people? That's it. Exclusion also we know. Next, what is the meaning? Company A has been unable to repay its debt and undergoing insolvency proceedings. One of its directors, Mr. X, holds a significant shareholding in another company, B. Who would be considered a related party under IBC and what is the significance during the process? You have to provide all the RPT points over here. That's it. Next, significance. Related parties are scrutinized during CRP because they can influence resolution outcomes and are restricted from voting in the COC to ensure fairness and independence. Very logical. Now next, under what circumstances can NCLT order liquidation? We know this, 4 points. Next, after liquidation, what? Public announcement, no new suits, liquidator is appointed, liquidator can initiate or defend cases. Now what is the meaning of preferential transaction? You have to explain over here, people. Then what are the orders that can be given by adjudicating authority? Next is what is the meaning of undervalued transaction? Next is what is the meaning of fraud transaction? And last is what are the options available to the secured creditors? That's it, people. If you solve these, if you just go to the expected questions and just revise using mind maps, people, simply you can easily get 7 marks. I want you guys, every single one of my virtual student should score more than exemption in corporate economic laws. People, you tell me, what all things do you require to score an exemption? Number 1 is you need crispy notes. You need sorry to use Hindi words. You should be having notes very, very to the point. Yes or no? It should be very, very easy to understand, read, remember. My notes qualify all the criteria, people. Number 1. Number 2, sir, I want to revise. For revision purpose, I have given you mind map. Sir, I also want examples to understand concept better. I have given you examples also, people, in this lecture itself. Now, people, I need expected questions. What all question can be asked? I have given you that also. Now, you tell me, people, if you get all these, I have also taught you how to write answers in the exams. People, that's it. Now, sky is the limit for you, okay? I want every single one of my students to score exemption in corporate and economic laws. Okay, people? So, if you have got any doubt with respect to any topic or any concept, if you want to say anything, just drop all your doubts in the YouTube comment section as quickly as possible. I'm going to make sure all your doubts are resolved in the most beautiful manner possible. Right, people? So if you need any help, if you need any guidance from my side, just reach the YouTube comment section. Okay, people? So that's all from my side. Eat well, sleep well, study well, people. Thank you so much for watching. I will see you in the next one.